Hi, and welcome back to the Protecting Your Family's Future podcast. This is episode number 97. Today, we are continuing our discussion on long term care planning. My law partner, Tim Alley, is back with us. Welcome back, Tim.
Thank you, Richards. It's a beautiful day in Holland, Ohio.
Excellent. It's a beautiful day here in Perrysburg as well. So, last week we talked about the Medicaid qualification process, and we looked at how a person is eligible for Medicaid to cover the cost of long term care. And we talked about countable assets and exempt assets. That was all pretty straightforward. But at the end of the discussion, you talked about how retirement accounts are treated a little bit differently. Well,
Right.
now, we didn't really have time to go into that at the time, but can you take a minute or so and maybe give us an idea of how that works?
Yeah, basically retirement accounts like IRAs and 401ks, if those are not in payout status, if they're not paying out an RMD or something like that regularly, then they are considered to be an asset and must be spent down. If they are in payout status by paying an RMD, required minimum distribution, or having distributions paid out monthly, then they are considered payout status and will be considered an income source so that the asset does not have to be spent down, but the regular payout, the regular payment income is considered part of the income and is counted in that way to determine eligibility.
Okay, so sometimes a retirement account is an asset, and sometimes a retirement account is income, depending on where a person is in terms of their receiving distributions from those retirement accounts. Is that right?
Correct. Correct.
Okay, so in the qualification process, that's a really important thing to know. Thank you. Now, you were also talking last week that the the Medicaid qualification process is going to be very different when a person is single versus when they're married. And you said, or I said, I'm not sure, that the state wouldn't completely impoverish the community spouse. Now,
Correct.
how does that work? What are the qualifications when a person is married?
So when an individual is married, the institutionalized spouse, still has to have their assets down to $2,000 and will only keep $50 of their income on a monthly basis. However, the community spouse, the one that's living at home, can keep one half of the value of the countable assets, plus they get to keep the house, plus a car, and if there are some other income producing assets, sometimes an additional home, sometimes farmland, they might be able to keep those and just have the income from that counted as income as well.
Okay, so just looking at the countable assets category, I think those other things you were mentioning, they're just not counted. Is that right?
Correct.
All right, so you said they can keep half of the countable assets. Now, is that if they have $10 million, they can keep $5 million, or are there exceptions to that?
There are some exceptions to that. There are minimums and maximums. So what every state has their own specific limitations, but in Ohio, our minimums and maximums are that for countable assets, a community spouse can keep half of the assets up to just over $154,000. They also can keep half, but the community spouse gets to keep a minimum of almost $31,000 of the countable assets.
Okay, so that's a lot of numbers flying around there. Maybe it's helpful to look at a couple of examples. So let's say the couple has in countable assets $50,000. What can the community spouse keep?
So the community spouse will keep the $30,828, and then the remaining 20-ish thousand dollars would need to be spent down for the institutionalized spouse.
Okay, so half would be $25,000, but that's less than the minimum. So the spouse keeps the minimum, right?
Correct.
Okay, so if they have $250,000 in countable assets, what does the community spouse keep?
So if there's $250,000 of countable assets, half of that is 125,000, which is less than the maximum of 154,000. So the community spouse would keep all $125,000 of the half of the countable assets, which is the 250.
Okay, all right. And what about $400,000 in countable assets?
So if there's $400,000 in countable assets, that runs up against the maximum amount that a community spouse can have. So half of 400,000 is $200,000, but the community spouse would only be able to keep 154,000 of that 200,000, and all of the rest would need to be spent down, and the institutionalized spouse would have to spend down their half as well.
Okay, all right. So in that case, less than half. And of course, the more you go over that amount, it's still the same, subject to the maximum.
Correct.
All right. But what about income? What can the community spouse keep of their own income first?
So the community spouse gets to keep all of their income. So whatever their income is, they will get to keep all of that income.
And when we're talking about income, we mean Social Security, pensions, retirement plan distributions, that kind of income, correct?
Correct.
All
It's
right.
not, if there's an annuity that's coming in, if it is voluntary, then they don't that's not counted as income because it's not, they have an option, really, is what it comes down to.
Okay. But what about the institutionalized spouse's income? That spouse is maybe receiving Social Security, has required minimum distributions from their retirement account. Can the community spouse keep any of that income?
It depends. It's a good lawyer answer, right?
Right.
Um, so the institutionalized spouse, or excuse me, the community spouse has to be able to have a minimum of about $2,500 of income in a month. So if the community spouse only has income of $1,500 a month, then they could keep up to an additional $1,000 of the institutionalized spouse's income to bring the community spouse up to $2,500 a month.
Okay. But if the
That's a little
community
confusing
spouse
too.
has, I'm sorry, go ahead.
That's a little confusing too, I understand.
Right. If the community spouse has $3,000 of their own income, then they don't get to keep any of the institutionalized spouse's income. That's how I understood that to be. Is that right?
Correct.
Okay.
Correct.
But if they have less than that minimum, then they can keep some of the income to bring their income up to the minimum. Right?
Correct.
Okay, great. So anything else that we need to know about when we're talking about married persons applying for Medicaid?
So a little bit more on the income side of things. There is a maximum income as well, and so sometimes if there are excess mortgage costs or excess health insurance costs, the community spouse will be able to get extra above the $2,500 to help pay for those things as well. And the Medicaid has some standard needs allowances that they put in place. So sometimes you can get over that $2,500 income for the community spouse.
Okay, so it really is, they look at the totality of the circumstances. They want to make sure that the spouse can have at least their minimum needs met. And that's good to know. So thanks, Tim, for that information. everybody come back next week. We're going to start putting all these concepts together as we start talking about how do we put together a plan for protecting assets for the cost of long-term care. Hope that everybody will come back and join us for that one. So thanks for being here today. We hope it was helpful for you, and we'll see you again next week. Thanks.